Yeah, we now look forward to our next session, which is the fireside chat. Honorable Justice Pratibha Madam, Judge Delhi High Court, and Mr. Chandarlal in a fireside chat. May I please request to come up on the videos, please?
I'm here.
Yeah. Good evening, Mr. Lal.
Good evening. Good evening.
And
How are you
welcome,
doing?
and thank you for giving us your valuable time.
Pleasure. My pleasure.
Good evening,
Hello.
ma'am.
Good evening. Good evening.
Good
A
evening.
very
Good
warm
evening.
welcome to
Yes,
Pratibha
thank you.
Madam, Judge Delhi High Court, and Mr. Chandarlal. We are really honored to have you both with us here today. The fireside chat. Justice
I wanted to
Pratibha
ask you, where's the fire?
It'll be created.
Okay.
As long as it's not a barbecue.
No, not at all.
Yes, please.
Okay, so yeah. Justice Pratibha M. Singh, Judge Delhi High Court. She's a well-known figure in the IP fraternity, and I feel I'll do no justice if I begin to introduce her. She absolutely needs no introduction. Equally, Mr. Chandarlal, who is a senior advocate, is a well-known figure in the IP fraternity, and he too does not even need any introduction. So I may just request you both to begin with your fireside session. And from the organizing committee, we have Dr. Ashwini Civil from Faculty of Law.
Good evening to
And Mr. Saurav Sachdeva from IP Ethicon. ICC is also the organizing partner with us. None of them from their side is available right now, but we will welcome you warmly, and we would just want you to begin with your chat. Thank you for giving us your time. Yeah, please. The session floor is all yours, ma'am, and Mr. Chandarlal.
Thank you. I believe I have the easier job of asking questions to Justice Singh. I'm equally happy to receive questions, but I'm told my job is to ask the questions, and Justice Singh, I think the difficult task is yours. So let me kickstart the session, and I think one of the questions that obviously comes up as a starting point is from a standpoint of litigation and litigating SEPs. What do you see as the key differences between litigation of regular patents and SEPs? And have Indian courts really, now adapted to patent litigation? How are they adapting to SEP litigation? So first, let's get what are the key differences between the two, and if there are any difficulties that these pose to courts.
Good evening, everyone, and it's wonderful to be with all of you. I've seen you've had a long program today, starting in the afternoon itself, and a number of familiar faces and familiar names who are speaking and who will be speaking hereafter as well. I can just give you the experience that I've had sitting on the IP division, both, of course, on the original side 2-3 years ago, and then now in the IP division. If you talk to me about non-SEP litigation, I can tell you one thing. Today I had a patent infringement matter which got decreed on the first day, which wasn't an SEP matter. And I can tell you that this will never ever happen in an SEP matter. So I think non-SEP matters are much easier to handle, because in a non-SEP matter, all that the court needs to look at is the claims of the patent which is granted, the infringing product, and whether they match. And secondly, if there's any, validity challenge to the patent, there may be 10-12 prior arts which are cited. But with the experience now one gathers on this side, you know that only 1 or 2 prior arts would be relevant, will be the most important prior arts. So if you're able to look at the claims and the defendant's product and 2 prior arts, you've got the non-SEP matter sorted, according to me. The problem in SEP is there are 3 or 4 further levels that the court needs to look at. To that extent, I feel that SEP matters are getting more and more complicated. In an SEP matter, you firstly need, because it's an indirect infringement, you need the claims of the patent, Then you need the mapping to the standard. Then you need to show that the product, of course, is compliant, standard compliant, which is not a very difficult job. Apart from that, the bigger problem is the negotiations between parties, the entire correspondence over 5 to 10 years or 5 years or 3 years to see if the negotiations comply with the Frand commitment. So there will be a lot of to and fro in the correspondence itself. Some will say they didn't show us this, some will say they didn't negotiate properly. So there is things to be heard on both sides in the correspondence. And it could be emails and emails and emails which have to be reviewed by the court. And finally, one has to look at the offers which are made, the counter offers which are made, and whether those are Frand compliant or unwilling licensee or not, and whether in an SEP an injunction should be granted. If not, how do you protect the plaintiff if you think that there's a valid patent? Then there's also the dimension of portfolio patents, because most plaintiffs come with portfolios and not just singular patents in SEPs. And the infringement is alleged only of 1 or 2 or 3 or 4 patents, whereas the portfolio could be 300 patents. How do you manage that? So I really think that SEP litigation, even to someone like me, is extremely complex compared to a non-SEP litigation. And due to the sheer amount of time that it takes in going through this entire record, then there is the validity challenges for 3 or 4 patents. You look at the prior arts for those. Then there is challenge to the essentiality in terms of the mapping. You have to look at those. So instead of 3 things which I would do a non-SEP case, I would have to do 15 things in an SEP case.
So, Justice Singh, here's a dilemma, and having practiced in this field for a bit, so I would think, and I want your opinion on that SEPs should be slightly easier. A, because it already has several licensees. So every SEP owner comes with a whole bouquet of licensees and pre-existing licensees. The law, as we understand it in the decisions in Unwired Planet and Huawei ZTE, is that the parties should have fairly negotiated, and that's on paper how they have negotiated. Yet, I believe implementers get away by what I call throwing the kitchen sink at the plaintiff, saying everything, the onus is on you. Why is it that these, at least at the interlocutory stage, and I believe India being largely an interlocutory based litigation system, why is it that these are not exposed quicker? And isn't it easier? Because now a challenge to the patent can always be done post setting of some rates which to be paid at present, or at least an interim order to some extent. The essentiality infringements can be denied, but now the rules have been amended. So there is a whole network of assisting legislations and previous law. Why is it that still it is seen as more complicated than a regular?
The reason I would think is this. In terms of the question as to whether validity, essentiality should be looked at the interim stage or not, the court has to consider and lay down the jurisprudence on SEPs, which is, according to me, yet to happen globally as well. If you look at Unwired, for example, it does say you have to do certain things, whereas Germany is having a completely different approach to SEPs. I'm sure US has a completely different approach to SEPs. And in my own view, India is trying to develop its own jurisprudence on SEPs. And I think we have been successful as a system so far. And we've been quite kind of insulated from the international jurisprudence. Basically, the thinking in India on SEPs is yet to develop, because there is, according to me, not been a very contested big SEP final judgment post-trial. Even at the interlocutory stage, multiple patents, multiple challenges creates the problem, and the portfolios create the problem, and the correspondence creates the problem. So until and unless we are able to, cut through the chaff and lay down some strict rules for SEP litigations, I think it may take another year or 2 before this jurisprudence gets settled.
And I also, again, from my experience, I also view that SEP owners are essentially looking for licenses and not for injunctive relief or any kind of, damages. They're really looking for licensing on Frand terms to the defendant. And having done the Dolby case, which we went through the trial in an expedited manner, and we came up and we argued finally, at the nth hour when the judgment was reserved, parties settled. Because if a settlement offer is made, the SEP owner will never say no, and it's a fair within Frand terms. Does that set bad precedents where settlements take place after a full trial, and therefore there will never be a precedent because an an implementer will always push you to the limit, say go through the trial, and you will always give me the option of paying the license fee, in which case I'll settle at the nth hour after you've shown me all the agreements, I've been through the whole trial. One case may be lucky where you finish trial in 6 months, but in another case it may take 5 years. So I then, in the meanwhile, don't have to pay. Is that you see that as something of a bottleneck, which in a non-SEP?
Yeah, according to me, the jurisprudence has to change. The thinking has to change for the simple reason that there will have to be strict timelines which are laid out during which negotiations have to conclude. Courts have to lay down that if you don't, from the beginning, suppose there is a beginning of a licensing negotiation, it can't go on never ending for 8 years, 10 years. That can't be the situation. In those kind of cases, an SEP should be as good as an implementation patent, according to me. And if the timelines are not laid out and they're not adhered to, then I think an SEP should be treated like an implementation patent, where I know, for example, when cases come to court in implementation patents, we are granting injunctions easier. We are putting them to terms easily because we know that there's no obligation on the plaintiff to license. When will the obligation of Frand stop qua the SEP owner? There has to be something to say that. If that can be agreed internationally, that if we are in negotiations for these 2 years or 3 years, and if these things have been complied with by the plaintiff or by the defendant, then the negotiations have to conclude within this period. Otherwise, an SEP is as good as a non-SEP.
So Huawei ZTE really sets it out that I must, as the SEP owner, must only reach out to the implementer, offering a license, explaining how infringement is taking place or how they're implementing the patents. The implementer must immediately come back and agree to a license, and then SEP owner, gives an offer, and then there's a counter offer. And if the offer and counter offers don't match, then some deposit is made.
See, in your long sentence, you had 5 ifs.
Correct. So now, in many cases,
so there is a dispute on whether the licenses have been shown, whether the defendant has been fair, whether the plaintiff has been fair. So there is a dispute start on all those ifs.
But once the moment this is lifted, all of this dispute is decided and the court rules one way or the other, then it should be like an implementation.
I think SEP owners and implementers should agree internationally on a policy level to, have some strict timelines and not stretch the period so long that the whole purpose of Frand obligations and SEPs is being defeated like this.
But would you agree that we are largely following the Huawei ZTE and Unwired Planet principles, or we are still struggling with that?
According to me, I don't think Huawei and Unwired are being applied in that strict sense that you are putting to me. I think Huawei ZTE and Unwired are being looked at by courts right now, and it is taking time for the courts to absorb those judgments and to apply it on facts and to see how Indian jurisprudence should develop. And I do think that we've made a large, movement on this. The kind of orders that SEP owners have been able to get in India, I think it is not internationally being discussed much. It is high time that these orders are highlighted, which have already been passed in at least 20 to 30 matters, if I'm not wrong. Because even in Unwired Planet, where so many other jurisdictions are discussed, there are Indian orders which are not even placed before the court there. And I do think that Indian courts have been quite, fair to both the owners and the implementers by maintaining a good balance And these approaches need to be discussed at an international level.
So do you believe these approaches in Indian courts have changed over time? Or was it something that initially, when it was still at its nation state?
I think initially they were evolving. But the kind of orders that I've seen recently in many matters that lawyers have shown me, I do think that Indian courts have been really striking a very good balance and protecting the interest of the IP owner or even the implementer, and making sure that nobody's businesses are really crippled, but still, balancing the rights, I think.
In front of this forum, I do want to acknowledge that you took the leadership role in coming out with the IPD rules, and we are the only high court in the country which has come out with the IPD rules, and I think it's working very well, and it has taken into account a lot of issues regarding SEPs as well. So how do you believe that the IPD courts would have or would change this scenario? Is it, how beneficial has it been, and what are those key benefits, and why should other high courts follow suit?
The IPD rules were a result of a lot of hard work by the committee. We reviewed about at least 40 different sets of rules from different courts in the world on IPD disputes. Just 1 minute. Sorry. So we reviewed about 40 sets of rules from different, about 10-15 courts in the US and other different jurisdictions, about 20 other jurisdictions. And we had to marry all those rules and practices, including from countries like Japan and other countries, and marry them into our CPC, into our Commercial Courts Act. It was quite a challenge because it may appear very simple as it looks, but it took at least 20 different drafts before we could arrive at these rules. The patent rules were already in the works when the IPD had to be set up. So we then had joint committee meetings for both of these rules, and we had a lot of inputs. I must acknowledge, for example, from someone like Justice Manmohan Singh, whom we consulted, Justice Naveen Chawla, Justice Narula, a few practitioners maybe, and of course my own team of researchers, etc. And these rules have been made after understanding the practices. And I can tell you, since March, I've been on this division, and my own discussions with the other presiding judges on the IP division. I really think that this has a very good future, for the simple reason that the number of matters and the practices that we are adopting right now are going to be kind of laying down the structure and the foundation. For example, there are cases where on a particular patent, we've been able to consolidate about 15 cases and one consolidated trial. So these kind of practices were completely unknown before. And I know, for example, because the IPD has the writ jurisdiction, the FAO jurisdiction, the revisional jurisdiction, we are able to transfer suits from the commercial courts to the IP division, merge the suit with the cancellation, and do that together. So these are all practices which we are adopting. We are now in the process of recruiting the law researchers who will be technically qualified. And as we move forward, I don't see the day being very far when in the IPD you will get absolute slots for conducting trials over 3 days and final arguments. I think that's the final future that I envision in the IPD. For example, we do miscellaneous work for 2 hours in the morning and then do maybe a couple of trials every day, and go on and render final judgment immediately after the trial concludes, or even appoint local commissioners to do trials and hear final arguments. So I think that the systems that we intend to adopt would be with the global best practices. That's the intention. And I know, as a matter of fact, that we now have the exclusive IP appellate division now in our Delhi High Court, where all IP appeals are going to one division bench. which I think is unknown hitherto. So there is a clarity, there's a consistency in the approach, and there's also the unpredictability has been, reduced to quite an extent. This has been also followed in, for example, the Gujarat High Court. I was speaking to a judge from Gujarat, and the intention there has been that it's been marked to one particular judge in Gujarat High Court with a note saying matrimonial matters, one more set of matters, and IP matters will be given precedence. So I'm looking at a movement across the country where high courts are really wanting to have their specific IP divisions, which should follow suit.
Let's hope the Supreme Court also gets an IPD.
I don't know if we will have enough matters for the Supreme Court bench.
I'm sure there will be. And there was an interesting observation by one of the judges on the IPD when repeatedly SEP cases come and there are defenses raised by implementers. And the learned judge said, is this a standard essential defense that all implementers use?
That is a good one. SEP and SED.
So now we introduced a new concept called SEDs,
Very
which became sort of very apparent because it keeps going back to the same judge who sees the same kind of defenses raised by diverse defendants. So I think these kind of benefits, the courts become sort of much more knowledgeable about the subject, and we lawyers are not able to veer the judge towards where we like to. There is an issue which I don't know if you'd like to comment upon, but there has become a new issue under the IDG judgment of now the implementers wanting all the licenses before they would, and the setting up of that the licenses must be shown before they will even negotiate. Do you have a view on the IDG judgment and how that is playing out? Whether that is something that...
when you mean IDG, you mean interdigital?
Interdigital, yes.
Okay, right now I think that litigation is partnered before me, so I won't be able to comment on it.
All right. So now from a multi-jurisdictional, SEPs also have a multi-jurisdictional, with courts setting Frand rates. There's a requirement for the courts to set global portfolio rates. So therefore, SEP implementation is also done cross jurisdictions. What would you say why would an international SEP holder litigate in India?
Last week, I was, I don't know, am I still connected? Can someone tell me if you can hear me? Yes, I think Mr. Lal, you're having a bad internet connection.
Oh, sorry, mine is bad.
I don't know.
Sorry, I thought. Okay, I'm sorry.
Yes. So the question that I understood from what you said is why should SEP owners litigate in India? I want to give you a very interesting observation which happened in my court last week. We were dealing with a case involving, I think, AdWords, wasn't it? And both the parties were multinationals and they were litigating in India on the Google AdWord. And I was told that India is taking a different view on Google Ads than the international jurisprudence. And so both these companies who had their basic offices in America or in Europe were litigating in India so I think that when I asked them as to why these two companies are litigating here, though they do have businesses here in India, they said that India is one of the favorite jurisdictions now on IP. So that is just as a matter of, an anecdotal thing.
I'll take some credit in that because I argued the DRS, which is today the holding the fort.
So the thing is that insofar as SEPs or non-SEPs are concerned, I think India is now kind of reconciled to the fact that we have to deal with patent matters. And the initial hesitation which we as lawyers or judges used to have is gone. Today, I can tell you that in the Delhi High Court, out of the 4,000 cases which are pending in the IP division, which includes matters which have been transferred from the IPAB, which is about 2,500, and about 1,500 suits over and above that, and other matters. In the 4,000, you won't believe that 600 to 700 cases are patent related. which is a huge amount. And a lot of them are appeals from the IPAB, which have been transferred, maybe 400-500 of them. But the number of infringement actions has increased on an annual basis. I recall that there would hardly be even 1 or 2 patent suits even in the early 2000s or 2000 till 2010, 12. However, thereafter, the average filing on patent suits in the Delhi High Court is around 50 to 60 IP suits, patent infringement actions, which is a lot. And the way patent filing is increasing in India, where Indian innovators are filing about more than 50% of the patents now, which used to be 20% just 3-4 years ago. I think India is becoming the hotbed of innovation in the next 10 years. And we will see a large amount of patent litigation, just the way trademark litigation is now between mostly even Indian businesses. There are foreign businesses, but there are a substantive number of Indian businesses who sue on trademarks. I think in the next 5-10 years, we will see a large number of Indian innovators and foreign innovators approaching courts across the country. So I do see a huge increase in patent litigation going forward.
Justice Singh, you are a sea of knowledge and we've just pulled out half a glass, but we are running out of time. I'm told you were given only half an hour, which is terrible planning by the organizers. I do want to open it up for a few questions. We have very little time, but anybody has questions for Justice Singh or myself, we'll be happy to answer them.
We have a question from the audience. So, in cases involving life and liberty, it is often said that the process is the punishment. Can this be said to be true even for SEP holders in case of enforcing their patents? Effectively, implementers can use or even abuse court processes as a negotiation technique to gain better bargaining power. How fair can this be? And if the implementers use this questionable tactics, then should the implementers be having a right to Frand rates? That's the question we have got.
Okay. Equating life and liberty with SEP owners' rights, I think would be a stretch. But having said that, the jurisprudence of SEPs is very recent and very nascent right now. I don't think either, SEP owners or implementers need to fret. It's only a question of a few more years. Internationally, I think the jurisprudence will evolve and things will get settled down very quickly. I mean, we are talking about maybe 10 years of SEP litigation globally. And 10 years is nothing in a history of patent litigations. It takes time for jurisprudence to develop. It takes time for principles to be laid down. It also takes time for market dynamics to play out, I think. And I don't think that there's any cause for worry, because as the SEP owners' dynamics changes, see, when owners and implementers, their roles also, merge into each other, this will automatically get solved, according to me.
And I couldn't agree more. Having fought for a lot of SEP owners, I know they come back with defenses, the implementers do. I haven't had the benefit of representing implementers, so mine is a very one-sided view. But I must say that the courts cut through the chaff and they do get to point. And I think, as Justice Singh had mentioned, there are over 30 judgments where SEP holders have succeeded, and many have resulted in settlements thereafter. So the courts do put the right amount of pressure on both. Cut through the chaff and get to the point. And as jurisprudence further develops, this will only improve. So whosoever's question that was a little pessimistic, I think there are better days ahead. I can understand some frustration and the reasons for those frustrations, but that's part of the growing up process. These are called growing up pains and they'll only improve. Any other questions?
I think I'll have to leave because there's a social commitment.
Yeah, thank you.
We are running. We are out of time in any case. So thank you very much, Justice Singh, for giving us this time, very valuable time of yours, and sharing your views.
I would quickly like to thank both the stalwarts for joining us on behalf of Law Center 2 Entrepreneurial Law Clinic, Faculty of Law, University of Delhi, and other collaborators for this event. And we are really encouraged by the presence of the stalwarts of the field. We are looking forward to the good times in the IP. Thank you.
Thank you to Delhi University and all LC and all.
Thank you.
And we'll meet soon. Thank you. Bye bye.
Thank you, ma'am. Thank you. Thank you so much. Thanks for joining. Thank you.
Okay, so that was a wonderful fireside chat session between Mr. Lal and Honorable Justice Pratibha Madam.